Welcome back to the Law and Crime Network. I'm Heather Hansen, and we have had quite a full day here at the Law and Crime Network. We have two different cases that we're covering, as you know. The one that we just left is the case against Bob Ward. This may be a little bit of deja vu for some of you, because this is a case that was already tried, and Bob Ward was convicted of the killing of his wife. However, that conviction was overturned on appeal, and we're going to talk with our guest a little bit about that process, because that's something that we don't always get to see. Because that case was overturned on appeal, it is being retried. And this morning we heard the defense argue a motion for acquittal, saying that the prosecution had not met their burden of proof. As often happens with those motions, that was quickly denied by the judge. And now the defense has called their first witness. Their first witness was the physician that treated the deceased spouse, Diane Ward, for a number of years. And what the defense seems to be getting from Diane, the physician, is simply that she was depressed, that she was on a number of medications, that she was extremely upset about their financial situation. Evidence to support the claim that perhaps the wife was the one who started the scuffle that led to her own death. That seems to be the defense's claim in this case. It seems to be what they're arguing. They're going to have to flesh that out a little bit more during their case, because we hosts, when we talk about this case, are sort of scratching our heads saying, what exactly are they saying? Was she suicidal? Was she attacking him? What exactly was going on? And you cannot have juries scratching their heads at your case by the end of the case. So hopefully they're going to, for the defense's side, going to be able to flesh that out a little bit more. We'll take you back to the Ward case as soon as it's live, but I know the case that many of you are watching with such bated breath is the case against Donald Smith. This case is disturbing, to say the least. I've seen some of you chatting about it on the chat room, and certainly not really happy about the way that this case has gone down. This is the case where Donald Smith is alleged to have sexually abused and murdered this young girl, Cherish Periwinkle. And that's her in the picture there. The interesting thing about what happened today in this case was, of course, we first heard the opening arguments from the prosecution and then the defense. And the defense's opening statement, to my ears, seemed to be in some ways blaming the mother of little Cherish Periwinkle. Rain Periwinkle is the mother's name. And saying that, you know, she let this young girl get into this van. This van had covered over windows. All of these things blaming the mother, which doesn't make a lot of sense to me. It's not as if they can claim the mother is the one that killed the young girl, but perhaps they were trying to establish that there was a period of time between the time that the young girl gets into the car with the defendant and the time that she was found, and perhaps someone else could have done it. However, when it came time to cross-examine Rain Periwinkle, a moment that I thought, given their opening, would be very strong, there was nothing. Smith said to his lawyer, I don't want you to cross-examine her, and they went on a break. So as soon as they're back, we're going to take you back. But in the meantime, I have the best guest to talk to me about this stuff. My friend Jonna Spilbor is here with me today. And wow, quite a day in both cases.
I know.
But I want to start with the case that I know the majority of our viewers are more attached to, and understandably so, this case against Donald Smith. What do you think about what happened right before lunch, where the defense seemed to be ready to cross-examine Rain Periwinkle? It seemed from their opening, which we'll go back and play in a minute, that they were plan to focus on her, and then the defendant says don't do it.
I know, which is strange on a number of levels. But let me ask you a question first. Did they dismiss the mother, or can they potentially recall her to conduct a cross-examination?
I believe she's still waiting to be conducted to cross-examine.
Because I was literally in the car when that was happening.
Right.
So here is what I think. I think over this break, the defense attorney is going to be having a big heart-to-heart with the client to say, wait a minute. You know, first of all, clients, even though they don't call the shots, obviously, you can actually represent yourself in just about any criminal case. But when you have counsel, you really have to be strategic and let your attorney do his or her job. And in a case where this is a death penalty case, a death penalty case. So I don't think the attorney's just going to sit back and go, oh, you don't want me to put up a defense? Sure, no problem. Next witness. I don't think that's going to happen here.
Yeah, and it's first of all, I think we're all struggling at what exactly is this defense. And that's why in a minute I want to replay the opening. It's not very long, so that we can sort of look at it and parse it a little bit. But if your defense is going to be something about the mother should not have left the child in his hands, which I don't know how that plays out very well, but you do need to cross-examine the mother in order to establish that defense, don't you?
If you're going to try to establish a timeline, it seems that they have a very loose, some other dude did it defense here, or at least what they're trying to put forth is some other dude could have done it defense, then you need to establish that timeline. And it seems the only way that they're going to be able to even get close to that is by rigorously cross-examining the mother. But I got to tell you, if I were the defense attorney in this case, you do not want to in any way, shape, or form blame the mother for the death of her 8-year-old daughter. That's a fine line that you got to be very careful.
I agree with you, though. I have to say, in my experience with juries, women tend to be harder on women, and especially women who are mothers tend to be harder on women who are mothers, for better or worse. The jury is a majority of women, and from watching our chat room and from talking to people about this case, there are a lot of people who are questioning why, and I don't know that it has anything to do with the defense of this guy, but there are a lot of women who are questioning why she would allow her child to go with this stranger and to walk around with this stranger and to shop for high-heeled shoes with this stranger and to leave with this stranger. And while I don't understand how it plays into the defense of this case, I do think with this jury, if you're going to try to make that connection, this might be just the jury to do it with, because you have such a high percentage of women on the jury.
Maybe what the strategy will be is the defense perhaps expects a conviction, right, in the guilt phase, but maybe those elements might come into play in the penalty phase, and therefore this person's life will be spared because the mother didn't make the smartest decisions in the jury's mind. I'm speculating here.
Interesting thing about that, I was thinking about this being the guilt phase as opposed to the penalty phase. And if this would be pure strategy on the part of the defense attorney and the defendant, but if the jury saw that he said, no, don't cross her, I don't want her to have to go through that, which is something, that's the effect of what he said from my understanding. And the jury saw that. Isn't that enough to maybe make one or two of the jurors say, you know what, he's a sicko, he clearly has problems, but he also has some level of remorse, some level of not wanting the mother to go through more than she already has, and maybe that's a reason not to give him the death penalty? Do you think that, I mean, that would be some really good planning on the part of the defense and the defendant?
It almost gives the defendant a little more credit than I certainly want to give him. And if you really play this out, let's suppose that we jump way ahead and he's guilty in the guilt phase. He would most likely take the stand in the penalty phase because there is no reason not to.
That's right.
There's no reason not to. So maybe he takes the stand and he can come out and say, I didn't want to put this mother through anything. Please spare my life. I'm sick. I've been sick. He's got a long history of being a sicko.
He is a sicko.
He wasn't even out that long before this happened.
Right, not like 3 weeks.
Yeah.
It's crazy. But let me just fix something that I said. I said Rain Periwinkle was not excused, and apparently she was excused. However, she can still be called in the defense case.
The defense can call her as their own
own witness. Right. So she has been excused from the prosecution, who called them as her witness. She wasn't cross-examined. But it doesn't mean that the defense can't regroup and call her in their case.
So if they do that, then they might want to declare her a hostile witness so they can ask the leading questions. If they call her simply as their own witness, then they would be only able to directly examine her, not cross-examine her.
Yeah, I mean, I definitely don't think that this was part of the plan. I definitely, unless, as we just said, it was this really strategic plan to ingratiate themselves to the jury and ingratiate the defendant to the jury to save off of the death penalty. And I would find that hard to believe, and it would be, I guess, sort of grasping at straws. But you had told me before we went on air that perhaps, and we don't know this and we will never know it for sure, but perhaps there may have been some plea bargaining that went on in this case before they got to trial. What do you think? I mean, we know that usually happens in these cases.
Especially in a death penalty case, because if the defendant is what we call dead to rights, meaning there's a lot of evidence of guilt here, the objective of a defense attorney then is simply to spare his life, get him life in prison without parole, as opposed to execution. And so those are the talks that typically take place. And you either have to have a prosecutor who has a personal feeling about this case and they don't want to give this guy a break. And if you're not going to give a guy a break, this is the case to not give the guy a break.
No joke.
Based on the history, based on the facts of this case. So perhaps the prosecutor said, I just have a fundamental problem with cutting him a deal.
Well, especially because he kept getting out. I mean, this guy is a sex offender, and he was arrested for lewd and lascivious, I always mess up that word. Yes, behavior back, I think in the 70s, if I remember my notes correctly. Yeah. And these people are sick, and a lot of times when people argue for the death penalty, it's people like him who have a sickness that is almost incurable, or at least arguably incurable, and that just can't help himself from repeating this horrific, animalistic, disgusting behavior.
Yeah.
It's and there's so much about this case that is disturbing. I mean, putting aside his behavior, because that's just beyond disturbing, and I have a hard time even talking about it, thinking about it, watching it. But the other thing that is, I got to tell you the truth, Jonna, I didn't realize that this was such an issue until this case and another case that we covered briefly just recently, this issue with Amber Alerts. So this young girl was reported missing by her mother that night, sometime around midnight. And Kathy's going to kill me because we had this great timeline and I don't just have it in front of me. But sometime around midnight. And the Amber Alert was not called for something up to 6 hours later. I don't understand how that can happen. Now, maybe that would have made no difference. Maybe the police would not have found the van. Maybe nothing would have been, maybe Cherish Periwinkle couldn't have been saved. But maybe she could. Maybe she could. And maybe if they had let the authorities know sooner, let the public know sooner, let people know sooner to keep an eye out for this nasty white van, something could have been different. And this is not the first case where I've heard that there's this delay. Now, in this case, it seems some of the police officers were actually disciplined over this delay. And it seems as though they didn't totally believe this mother. Do you think that there's socioeconomic things that come into play with this type of, so you've got this young poor mother who's calling her, calling from Walmart at 11 o'clock at night, talking about some guy she's been walking around with. I mean, do you think that that story just doesn't ring as urgent to the person on the other side of that 911 call?
That begs a question for me, and that is, whose job is it to determine the veracity of any 911 caller? When you're under stress, or who knows, or you could even be under the influence of something. That doesn't mean that an emergency isn't occurring. Why do we not take all of those calls seriously, except for the ones that say they've been abducted by an alien and they're on their way to Mars? All right, those are different.
Right.
This was information that was verifiable.
It's so funny because when we were driving in this morning, I was talking to my boyfriend about this case, and I was saying that what's the harm? You put out the Amber Alert. What's the harm in that? Now, it may be, I don't know what the cost of resources of doing that is. It may be that it's expensive and you don't want to waste that money. But guess what? I would rather see the money wasted than Cherish Periwinkle's death on your hands.
Precisely.
And I think that the public perception of this, back when this happened in 2016, the coverage was a lot about the delay in the Amber Alert. And they asked Periwinkle, the mother, about that, and she said she couldn't comment. Do you think there's the potential for a lawsuit there, Jonna?
I was going to say the same thing. Potentially, I think there is. But the problem, so now you're going to have a causation problem. Because as you just mentioned, there's no way, or perhaps there's very little way to prove that it wouldn't have happened anyway, even if they were on that Amber Alert like that.
Yeah, and that's the type of case that you might see settle because they just don't want that kind of negative publicity.
No,
but let's back up and talk a little bit more about what we're talking about here, because both of these issues were mentioned in the defense openings. The issue about the mother and some judgment of the mother for letting this happen, and the issue of the police department and all of those resources not coming to bear right away. Both of those were mentioned during the opening argument by Julie Schlacks. So opening statement rather. So what I'd like to do now is play that opening statement. It's short. While we wait for the case to come back live, we will bring you back there. I know a lot of you are wondering whether it's live yet. It is not. The minute it is, we'll bring you back. But for right now, I want to play that opening so that we can really parse apart the details and what it might mean, that fact that Rain Periwinkle was not cross-examined by the defense.
Good morning. We are here in this courtroom because the state of Florida is seeking the death penalty. And you have just heard an emotionally charged opening statement designed to anger you. What we are asking you to do as Americans in this country is demand the state of Florida live up to their burden of proof, for they share it alone. Do not make any fixed opinion at this moment, but listen to all of the questioning, including the cross-examination. I will be upfront with you. There will be many people Mr. Fletcher and I do not cross-examine. We will help you test this evidence that the state brings forward. And unfortunately with that means that we will cross-examination. Right, for the state told you that she traveled to this area about a mile from her house at about 6:30 at night, knowing that her daughter not only was going to California the next morning, but would have to get up at 4 o'clock in the morning to make a 6:30 flight. And so she brings these small children, 8 and under, one pushing a stroller, into both Dollar General and Family Dollar. She uses $31 of the $100 that I guess she had allotted and bought miscellaneous things from the home. She decides against a $7 dress for Cherish. And although she will describe the stranger she ultimately entrusts to have watch over her children as creepy, she will tell you that at about 9 o'clock at night, having shopped in these first 2 stores for almost 2 hours, she makes the decision to get into a white van with shuttered windows, no proper seats, and place her children in that van. She goes with a complete stranger to a Walmart over 8 miles away, without any kind of cell phone, without any kind of transportation home, without even having public transportation as an option, for that shuts down at 9 o'clock. And you'll see surveillance tape of where she walks with this stranger and shops for over an hour. And she doesn't flinch when Cherish, and you'll see this with your very own eyes, wanders off with this stranger. Not once, not twice, 3 to 4 times. And she thinks nothing of the fact that this person claims, I'm going to go get cheeseburgers, and Cherish just wanders off. You'll watch the videotape. It will be 39 minutes between when Cherish Krenwinkle leaves her mother's sight and 911 is called. You're also going to hear, I anticipate, from 2 people that were married at the time, the Rosiers. They were in, waiting for their father with their little, I believe, newborn baby, in the parking lot. And a white van comes over, and they roll down the window, and never having known one another before, this stranger says, "Follow us. We're going to get cheeseburgers." Ultimately, they will come in, and they will identify that stranger. And they will tell you, we don't know if anyone else was in that van, but we literally thought, maybe we do know him, maybe he somehow knows the father they were trying to wait. So they eventually go to McDonald's that's physically outside of Walmart, about 2 miles away. They didn't move him. All of these details will be important, ladies and gentlemen, for you to make legal decisions in this case. On June 22nd, 2013, a beautiful young child lost her life. And I won't mince words, it is horrendous.
Ladies and gentlemen, that was the defense opening statement on behalf of Donald Smith. And Jonna and I are here shaking our heads because, well, the first thing to note from that statement is one of the major things, and we've talked about this before, Jonna, you as an attorney have to maintain credibility with the jury every step of the way. So you never make a promise in an opening that you can't keep in your case. And here she's saying She's apologizing for the fact that she's going to have to cross-examine the mother. And that's the majority of her opening, the fact that she plans to cross-examine the mother. And then she doesn't cross-examine the mother.
Right.
Definitely not part of the plan, don't you think?
No, not part of the plan. And that's something, if they actually end up not talking to or questioning the mother at all, that's something that this defense attorney is now going to have to address in her closing argument, because the jury's going to want to know. Unless, like you said, perhaps the jury actually saw and was paying attention to what was going on when that decision was made.
Yeah. And so she doesn't lose the credibility. They just realize that her client told her not to cross, which could help him. And we talked about this before, that could help him when it comes to the penalty phase. One person, just only need one, one juror might say, this guy's sick, he needs to be locked up for the rest of his life, he should never ever get out of jail, but his sickness did not make him so bad that he wanted to put this woman through even worse torture. I mean, I just can't even imagine. But I also have to say, taking a step back, if they were going to cross-examine her, what are you going to say? She's talking about the van and how dare she let her daughter go with this man.
Right.
We've said it before. That has nothing to do with the defense of this case. Nothing.
Nothing. Unless, that, like I said, they're trying to establish some sort of timeline to give a window to somebody other than this defendant to be the actual perpetrator, which is still a stretch, because you really need more than that in order to have a successful third-party defense, which I think is the only thing that they might be able to hang their hat on here. And even that, come on, it's weak. This is a case that is so difficult to defend because there really is no defense.
There's no defense. There's no defense. And in fact,
really
someone pointed out the whole reason that this case is being tried is because the prosecution allegedly, from what we understand, and we never know the ins and outs of this, but they wouldn't take the death penalty off the table. And I've got to say, no matter how you feel about the death penalty, you've said this before, this is a death penalty case.
Sure
if there's
is.
ever going to be a death penalty case here, you've got a guy who's a repeat offender, who is, okay, we have to go to a clip real quick. We're going to throw to the prosecution's opening while we fix my mic, and we'll be right back.
Cherish Periwinkle was 8 years old. She weighed 67 pounds. Separated from her mother, her little sisters, from all she knew as safe in this world. She spent the last petrifying hours of her life with him. He gagged her. He raped her. He sodomized her. And then he strangled her. He gagged her with such force, her gums and her nostrils bled. He strangled her with such force, her eyeballs bled. Cherish did not die quickly, and she did not die easily. In fact, hers was a brutal and tortured death. And after he killed her, he pulled her little, lifeless body through the woods, pushed it under the water, forced it under a tree, and took asphalt, bricks, and debris and weighted her down. Because he planned for no one to find her. But as you learn, things did not go according to his plans. He was caught. She was found. And though not in enough time to save her young life, in enough time to collect and gather the incriminating evidence of his guilt. Evidence on her body and in her body that would tell us, and now will tell you, the grim truth of her horrific death. This is our chance now to tell you about what that evidence is. I'm Melissa Nelson, and together with Mark Khalil and Vanessa Sanchez-Wheeler, we represent the people of the state of Florida in this matter. And as Judge Cooper has told you, the state of Florida has indicted the defendant, Donald Smith, with the kidnapping of 8-year-old Cherish Periwinkle, with the sexual battery of Cherish Periwinkle, and with the first-degree murder
of cherished periwinkle. In lay terms, for taking, raping, and killing her. Ladies and gentlemen, the evidence in this case, piece by piece, we will present to you and show you and prove to you an insurmountable case of guilt in this case. So what can you expect? Defense counsel told you last week that the evidence in this case is both gut-wrenching and gruesome. Those were their words. It is graphic, it is disturbing. And while last week during jury selection there were moments of levity where we, and he, even laughed, I assure you there are no moments of laughter in this trial. I do not think it will be an overstatement to say that each of you will be changed at the end of this trial. The evidence is graphic, but every person has a constitutional right to confront the evidence against him, no matter the weight, the nature, or the volume of that evidence. It is your job to look at that evidence. The evidence of his destruction.
Welcome back to Law and Crime Network. I'm Heather Hansen, and that, ladies and gentlemen, was the prosecutor's opening. Interesting little aside in this case, Jonna. You've got a female prosecutor doing the lead, the female defense attorney, and a female judge, Judge Mallory Cooper. That's unusual. I don't think I've been in a courtroom where that's been the dynamic, and it does play into the dynamics of the case a little bit.
I think the most important dynamic here is that you have a female defense attorney on a case like this, and a majority of female jurors, so with the hope that perhaps there can be a connection as much as jurors and defense attorneys can connect.
Right. It looks like we're coming back to the courtroom, so we're going to do a side-by-side so that you know that you're not missing anything there in the courtroom. We will bring you back live to testimony as soon as we have it, which may be right now. Here we go, ladies and gentlemen. We'll take you right back to the case. All right, ladies and gentlemen, this is some scintillating testimony, but what we're seeing is the surveillance from the dollar store from the occasion where Rain Periwinkle, the mother of Cherish Periwinkle, the little girl who was killed, meets up with Donald Smith, and this terrible series of events starts in motion. Jonna, how important do you think that this is, or is it simply something that we lawyers have to do to establish what we need to establish as far as authenticating these videos?
Yeah, it's the latter. And, you know, a lot of this evidence is evidence that isn't going to be refuted by the defense. This is just establishing, again, the timeline, the fact that they met, where they were. We had the witnesses on the stand to verify that this is how we do things. These are going to be the actual videos.
Welcome back to the Law and Crime Network. While they do this sidebar, I wanted to take the opportunity to get Jonna's insight before she has to go for the day. I mean, what did you think about that video that we just watched, other than the fact that it was tragic and scary and sad?
You know, I had a similar feeling to you, and that is there just was so much opportunity to have this crisis averted. Yeah. So much in hindsight now. And although I do think, in terms of the effect on the jury, it's going to impact them.
We're going to... All right, Jonna, so now they're at a recess because they're going to be showing another video, and this next video is about an hour long. But you were interrupted, so I want you to finish your thought before I ask you some questions.
I think the video that basically shows the length that this defendant went to coerce this mother, right, and her children, but I'm sure that it was the mother that he was focused on, and to get them to go with him, to put them in his van. Now, the jury is going to know this was planned, this was premeditated.
Absolutely.
So in terms of the defense wanting later to present somebody else did this, I think jury's going to sit back and go, I don't think so.
No way.
Right.
No way. And there's no cross for this type of thing. You know, before they were saying that, one of the cross-examinations that she did with the Walmart employee was, well, he would have known, I think it was actually the male attorney that asked this question, he would have known there were videos all over the place and that he was being videotaped. He did not care.
Did not care.
This man is a repeat offender,
right.
You know, and you and I were just talking a little bit off camera that if the jury finds out about that his first arrest was in the late 70s, that he had been registered as a sex offender in 1993, and that he had just gotten out of county jail, not prison, 21 days before this, that I would think would even put those people who, because these jurors, apparently the majority of them put themselves somewhere between a 2.5 and a 3 as to whether or not they were comfortable with the death penalty.
Right.
That might put a lot of those people towards 5.
It very well could. But without the defendant actually testifying,
Right.
I'm not 100% that that information is going to get in and be presented to them. And, you know, and not for nothing, I don't judge people based on their looks, but when you look at this defendant, he looks like somebody's grandpa. Right? He doesn't look like, I don't know, I don't know, what is a killer supposed to look like?
Well,
right?
Yeah, that's it. I mean, what does a sex offender look like? He definitely looks different sitting there talking to his attorney than he does when he is in that video and when he approached them. But you and I were sort of talking back and forth as to, you know, why would this mother go with him? And I do want to be careful because the mother's not on trial here.
I know.
And it's easy to go there. And I think, you know, I always go back to the psychology of these things. Psychologically, we want to believe that this could never happen to us. And so then we find reasons to support that belief that this could never happen to us by saying, I would never let my child go in that van. I would never let my child with this man. But if you are desperate for clothes for your children, for money for your children, not to have to walk 3 miles back home in the rain to be safe and back at home, and some man who says he's a Christian waiting for his wife offers you a ride in his van to buy some clothes for your kids, you know, you can understand. And this poor mom has to live with this every single day. The lost opportunities we're talking about.
Oh, yeah.
Every single day.
No, I am sure she beats herself up on a daily basis. I'm sure she blames herself. And look, this guy knew where to go.
Yeah,
he knew what
right.
to say. He didn't target people at Tiffany's. He was targeting people at Walmart
That's
and
right.
and dollar store, right? So he knew. So therefore, he knew the right words to say, and he knew that enticing them with the hope of buying them provisions.
Yes.
Would work, and it did.
Yeah, it's the same way that sex offenders are known to offer little kids candy. This is the equivalent. Often offer a mother who is clearly has some needs, the exact things that she needs. And it's not for her. It's not like he was offering her drugs or alcohol or any of the things that we sometimes see. This was things for her children, which is even a greater need for a mother to want to be able to give something to her children. I have to say that this case bothers me more than any case I've covered since Law and Crime started. The very first day. It's just so disturbing. And there's so many things, you know, we talked a little bit earlier about the Amber Alert. And all told, Kathy, our trial producer, has told me it was about 6 hours between the time that she called 911 to the time that the Amber Alert was called. And while some people might say, well, he was immediately going to do something, I don't want to get into graphic detail, though I'm sure, unfortunately, we're going to hear some graphic detail, but he did not kill her right away. And so he was doing the other things that he's been charged with before he killed her. And so there is a chance, arguably, that her life could have been spared had something happened sooner. And one of the things I wanted to talk about is some people had asked, well, how long do Amber Alerts usually take? My understanding, in having spoken to some law enforcement, is the minute you get that call and you've determined that this is actually a case that the Amber Alert is appropriate, the alert goes out right away. Is that your understanding as well?
That is my understanding too. And I've seen it, I drive a lot between here and New York City and other places, and I see Amber Alerts all the time.
Yeah, all the time.
And I see them a lot for adults, missing adults. So, I mean, the system is in place. And I've also received Amber Alerts on my phone.
Yeah, me too. And it's like the big beeping noise. It's definitely, there's definitely some things slipped through the cracks here.
But that's another thing. I think this defendant planned it so well. I mean, the crime was happening primarily late at night, where fewer people are going to be able to observe a van. You know, most people were asleep. That's right. Basically at that time. So he had a big span of time where he could go undetected, even with an Amber Alert. Even with the Amber Alert. And I think he planned that as well.
Of course. I mean, to have spent that much time in the Walmart, sort of cruising around the Walmart, and then taking her to the McDonald's, which is at the front of the Walmart. So it's not like he was telling the mother, I'm going to take her in my car to the McDonald's down the street. I'm just going to walk her over here and get her something to eat. It is 11:15 at night. Most 7-8-year-olds probably should be home in bed in their pajamas. It's I don't know. This is a difficult case to watch. I'm trying to think back in the cases, and you've been here with us for some of these other death penalty cases. I don't think we've had a case here yet, and someone I'm sure will correct me if I'm wrong, where the jury actually did say, yes, we want the death penalty for this defendant. I don't think we've seen that. I think that might change with this case.
Yeah. Well, if ever there's a case where I would be compelled to vote for death, I'm sure you would be compelled to vote for death, regardless of your feelings on the death penalty, it is this one. There's just this was no accident. This was a compulsion.
Been unable to buy that dress. And then he told her that he and his wife had a gift card to Walmart that they didn't need. And he would love to be able to share it with Rain. $150. To Rain Periwinkle, that might as well have been $5,000. $150 for Rain Periwinkle would mean that she could buy dresses for all 3 of her little girls, not just Cherish. He told her that his wife would meet them at the Walmart 15 minutes away. But you'll learn this was a lie, a scam, a trap. Because Donald Smith didn't have a wife. There was no gift card. In a terrible, irresponsible, and forever irreversible mistake, Rain Periwinkle agreed to that ride. Rain believed this man. She believed his offer of a helping hand. And she and her 3 daughters got into his car, a van. You will inevitably wonder how could she be so naive? How could she put her own children at such risk? But you'll have the opportunity this morning, in fact, to meet Rain Periwinkle. The nice thing about trials is that you get to meet people at the witness stand. And I suspect it will become abundantly clear to you why he picked her, why he selected Rain. You see, her naivete is what he needed to get what he wanted. At 8:38 p.m., Rain and her daughters got into this man's van, and they left to go to Walmart. They arrived maybe 15, 20 minutes later. He continued his cunning ruse. He told Rain to go ahead into Walmart with her girls, that he was going to keep waiting on his wife, and that he would come in when his wife arrived with that gift card. Rain started shopping. $150. She didn't go to the makeup aisle to shop for herself, or the women's clothing section to shop for herself. She filled her cart with 3 small piles of clothes. One for
Welcome
each.
back to the Law and Crime Network. We're seeing a little bit of action in the courtroom for Donald Smith. It may just be that Donald Smith is back in the courtroom waiting for the jury to come back. They were given a break, and as the judge pointed out, Jonna, with this many jurors, these breaks often take, it's like herding cats. You know, that one juror wanders off, and then you think you have everybody, and so 15 minutes sometimes takes longer. But apparently, are we back live in the courtroom? Okay, I'm going to throw you right back there live now.